Hey there, and welcome to Criminal Justice in a Nutshell. My name is Dr. John Fisher. Today's episode of Criminal Justice in a Nutshell is death qualification, also the death penalty jury selection. Okay, I am filming today from the Cahoma RV Park in Cahoma, Texas, right off of Interstate 20. If you've watched a previous episode, I showed you the interstate over there. It's going to be loud, and you're going to hear the vehicles behind me. We are in a busy part of the world right now. I saw an advertisement on TV the other day that said this is the center of the universe, or the center of the world as it comes to petroleum. The Permian Basin is producing more oil than anywhere else in the world, and everybody's coming here. So let's get on to the business of finding 12 people. 12 Angry Men. And I'm thinking about the movie A Time to Kill. Time to Kill is starring Matthew McConaughey and Samuel L. Jackson. I love that movie. I show it in a lot of my face-to-face classes. If you have the opportunity to watch this movie, do so. Or better yet, read the book by John Grisham, A Time to Kill. It gets into a lot of what we're going to be discussing, or what we have been discussing over the last several videos. Okay, so finding 12 jurors is hard to do. And it starts with voir dire. And I say voir dire, it's a French word. Other people call voir dire, voir dire, voir dire. There's so many different ways to say these words. It's French. I don't speak French, so I call it voir dire. Okay, so voir dire starts with questioning. It's a way for the attorneys to ask questions of potential jurors, also known as panelists, to learn their beliefs, their conflicts, their preferences, and their prejudices. And then they can determine or decide whether or not they want these people to sit on this jury. Seeking a death penalty jury is even more difficult, because we have to look at what's going on in the world. We have to figure out why and what and how these people believe. And there used to be a policy or a process that started in the 1830s that is death qualification. And that is when a prosecuting attorney decides, well, let's back up a second. There are two kinds of challenges that can be made in selecting a jury. The first is for cause. And a for cause challenge, or striking a potential juror member for cause, is because they have a direct conflict or bias. One of the first questions a judge will ask is, hey, this is this case. This case is over Stephen Avery. Do you know Stephen Avery at all? And people raise their hands. Goes, do you like Stephen Avery? Are you friends with Stephen Avery? Do you hate Stephen Avery? Okay. Do you think that you could try this case and be unbiased in the process? And then if the judge believes that they can't, or he'll dismiss him, strike him. Then they'll always ask, do you know the district attorney? Do you know the defense attorney? How do you know him? What do you think about him? And these kinds of things. One of the questions that used to be asked was a disqualification, or the death qualification question. And it was done in Illinois. The particular case that we're talking about was Witherspoon versus Illinois. And what happened is this judge, he'd say, let's save the time of everybody here. All those who oppose the death penalty upon some moral or religious scruples or conscientious religious scruples, please raise your hand. Go home. We're not going to deal with you. And that's what was called Witherspooning, because now all of a sudden we have a jury that's more likely to convict. We have a jury that's not only more likely to convict, we have a jury that's going to send you to die. Okay? So, Witherspoon versus Illinois started the limits and started restricting death qualifications in death jury questions. Okay, so they still did leave a qualifier. And that is if a juror goes up and before the trial starts, in advance of the trial, and they confide in the judge and say, hey, excuse me, Your Honor, I'm sorry. There's absolutely no way I'm ever going to consider the death penalty as a punishment. If the juror does that in advance of the trial and confides in the judge, you know, Judge, I don't care what this man did. I don't care how bad it was. I don't care the conditions or the circumstances. I'm not going to sentence him to die, period. The judge can then remove them from the jury. But just because they have some conscientious objector status, or it's against their religious morals, or their regular, non-religious morals, that the death penalty is wrong, that does not automatically exclude them from being able to sit on a jury. Okay, so Lockhart versus McCree, the court turned around, and this was a social science experiment. And this is where we put social science on trial. And social scientists like myself, I'm a social scientist. I try to find out why people do the things that they do, not on an individual basis, but as a group, as a society, as a community. So what we found, what the social scientists found, was that even a permissive death qualifier or death qualifying statute would increase the likelihood of a death sentence. Because if we've got people that are willing to sentence people to die, they're actually going to do that if it comes about. So it's going to increase the chances of a death sentence, and it's going to prejudice the jury. Science lost this battle. The judges discredited, and they discharged all of the claims that was put forth by science, and said, you know what? That doesn't matter. Beck versus Alabama of 1980 case, the jury must be instructed that it can also convict on lesser included offenses. A jury is able to convict somebody on a manslaughter charge or a second-degree murder. If we're going after the death penalty, the district attorney, the prosecuting attorney, has to include lesser charges. And the death penalty and the jury must be advised and instructed by the judge that they can choose one of those lesser sentences or lesser charges. The next case was a 1985 case of Caldwell versus Mississippi. Caldwell versus Mississippi stated that a jury could not be left with the impression that it should be anything less than fully responsible for deciding the fate of an individual. Caldwell versus Mississippi, the jury had to be instructed that this man's life or death is in your hands. Okay. You cannot blame this on the district attorney. You cannot levy it on the judge. This is you. This is your sense of responsibility. Okay? And at no point can this sense of responsibility be diminished in weighing the death penalty. Okay? So, a professor named John Bloom noted that whether a client is ultimately sentenced to life or death is determined during the voir dire. The results of this case are determined by the evidence that is given during the guilt phase of the trial. The death penalty is going to be determined based upon voir dire and the beliefs of the jurors that are selected. If a jury is death qualified, it is more probable that the jury is going to end up sentencing to die. One of the other things that science came up and showed was that a death qualified jury is going to be more closely or be likely male, white, conservative Christians, also known as WASPs, white Anglo-Saxon Protestant males. Okay, they are more likely to expect individuals to have respect for authority. They are more likely to believe a prosecuting attorney, and if a prosecuting attorney is bringing somebody to die for a sentence of death at trial, they're going to more likely believe that that sentence and that punishment is necessary and required. So if the evidence shows that the defendant is guilty, he's most likely going to end up on death row. But back to A Time to Kill with Samuel L. Jackson. After they completed voir dire, Samuel L. Jackson leans over in his chair and he says to Matthew McConaughey, he goes, "Look at that. That's a jury of my peers." The jury was mostly white, mostly older. I don't remember any minorities being on the panel. And that's what you end up with when you're dealing with seating a jury. And this is why we have the claim that death penalty juries are racist. Because a lot of times the defendants are people of color. The juries are majority white. Even the jury itself is majority white. Even if there are a few people of color on the jury, it's more likely than not that a death-qualified jury is going to find the defendant guilty and sentence that person to die. So, this is Dr. John Fisher, and criminal justice in a nutshell, jury selection for death penalty. Have a good day.